finally, under the pressure of American bombing.
After nearly 8 years of fighting,
In Paris, on Avenue Kléber,
Vietnamese returned to the negotiations.
more than 4 years,
ending a war.
The following statement is being issued at this moment in Washington and Hanoi.
armies from both countries would hold their positions.
To talk about a war in which nearly 1 million men have died, the Vietnam War.
The agreement will be formally signed by the parties participating in the Paris Conference on Vietnam on January 27, 1973, at the International Conference Center in Paris.
On 27 January 1973, parties like the US, South Vietnam, North Vietnam, and Vietcong have signed an instrument known as the Paris Peace Accord that opened the way for the conclusion of the Vietnam War, which had been fought by the related parties since the 1960s. The Paris Peace Accord was the outcome from the negotiation process that has been conducted secretly between Henry Kissinger, the US National Security Advisor, and Le Duc Tho, member of the Vietnamese Communist Party Politburo, from February 1970 until January 1973. This process complemented the formal negotiation process conducted by the parties to the Vietnam War that aimed to conclude such war which have affected them negatively. To have a better understanding about the historical event like this, we need to learn first about what is a negotiation.
To begin with, an international negotiation is generally a process of power-based conversation meant to attain a specific aims or ends, and which it may or may not completely settle a particular disagreement or conflicts to the satisfaction of all parties. Therefore, to settle disagreement and prevent the use of force, it is claimed one must negotiate. Negotiation demands a willingness to compromise, and both parties must make compromises. Neither side can hope to win everything at once. If both parties negotiate in good faith, they can always reach a fair settlement. If there is debate concerning numerous problems, the less contentious one should be settled first, since it will lead to a greater agreement. A negotiator should never make a trade if he is not prepared to follow out, and therefore each side has its minimum beyond which it cannot be pushed. Furthermore, negotiation may be bilateral or multilateral, public or secret, and can entail diverse types of negotiation with states and non-state civilian players, as well as with anti-state actors such as individual terrorists and terrorist groups. In addition to that, distinct cultures may participate in negotiation with differing approaches and for differing objectives with varied expectations. Negotiation targeted at conflict management aims to restrict or eliminate tensions and disagreement as much as possible without necessarily affecting the status quo or the relation of power, values, and interests between the contending parties. Additionally, negotiation targeted at conflict transformation aims to move beyond the status quo to shift relations of contested power, values, and interests in a more positive and less contentious direction, despite primarily anticipating a number of conflicts and disagreement to continue. Conflict resolution is often considered as an even longer-term process that strives to discover a common and comprehensive agreement among the diverse parties despite their varied values, interests, and power connections.
Negotiation is considered the oldest and most straightforward method of resolving conflicts, and it's also a method of disputants parties settling their disputes through dialogue or changing their disagreements. For example, in the event of a disagreement, the process of negotiation may be employed to establish a peaceful compromise. This negotiating procedure may be carried out by the head of state, their representative, or diplomatic agents. However, the effectiveness of this strategy is heavily dependent on the degree to which one party's statements are accepted by the other. It does, however, have several flaws. On several occasions, it has been observed that reaching an agreement is difficult. So why do states make a negotiation or international negotiation with other states? So in many negotiations, both parties are aware of their interests and are prepared to participate in a give-and-take process with the other side to reach an agreement. However, in these agreements involving personal identity and firmly held views or values, negotiating dynamics can grow more complicated, necessitating different disputes resolution strategies for conflict resolution. Parties may be unwilling to give any concession that benefits the other side, even if it results in a reciprocal concession that benefits them. Lastly, most parties have many goals or aims in mind, albeit one may take precedence. Furthermore, even though the participants are in the same negotiation, they may have distinct goals. Sometimes parties or states will enter into a negotiation process without reaching an agreement because their interest is more focused on achieving other goals, such as maintaining contact or relationship with the other parties, or substituting for violent action, intelligence, or deceit and propaganda, and also influence on the third parties. Each side of the state parties can encourage or discourage the opponent through the proper use of caution, bluffs, threats, and pledges. The bargaining reputation of the actors, their personalities, domestic affairs and difficulties, and the clarity of the opponent's intentions all influence on how an actor behaves during a negotiation.
Everyone, my name is Wan Zafifah. In my topic, I will talk about the basic to conduct negotiation in the international negotiation by the state by the UN Resolution 53/101 in 1999. In order to some country to create a negotiation or to establish the conduct of negotiation by the state in the UN Resolution 53/101 in 1999, they must include this element. First thing first is the element reaffirm, which is the following principle of international law which are relevant to the international negotiation. As we already know that all countries are sovereign regardless of their differences in economy, social, political, or other way. In this situation, states have a duty not to interfere in the domestic affairs of other countries in accordance with the United Nations Charter, and a state have a duty to fulfill their international law obligation in international negotiation. In this part of international law is important for the negotiation itself. Second is the element of the affirm element, which are the importance of conducting negotiation in accordance with international law in a manner compatible with and conducive to achieving the stated goal of the negotiation and in accordance with the following guidelines. For the first guideline is the negotiation should be conducted in a good faith. Second, states should consider the importance of engaging in international negotiation in an appropriate manner for the state whose vital interests are at stake. Moreover, the state should adhere to the mutually agreed framework for conducting negotiation. Apart from that, states should strive to maintain a constructive atmosphere during negotiation and abstain from conduct that could jeopardize the negotiation and their progress. And the state should facilitate the pursuit or conclusion of negotiation by remaining focused on the negotiation primary objective throughout. And lastly, the state should use their best effort to continue working together throughout in the negotiation. To conclude that, in general, we can say that every state or every country to make a negotiation in the international global should follow this UN Resolution 53/101 in 1999 because we can make a better negotiation by following this step of a principle that has been stated.
Moving on to the principles applicable to diplomatic negotiations. Generally, there are no specific rules in carrying out negotiations during the settlement of disputes. However, to make negotiations successful, it must adhere to public international law principles during the negotiation process. International conventions include references to principles such as peaceful settlement, cooperation, and good faith, which must serve as guideline for conflict resolution. This can be seen in the Article 300 of the 1982 Convention on the Law of the Sea, Article 17 Clause 2 of the 1997 Convention, and Article 4 Annex 2 of the Marrakesh Agreement. Alright, we are going to look at each principle in detail. First is the principle of sovereign equality. In short, this principle portrays states to be equal with one another. However, there is a disadvantage in using this principle, which it allows the use of differences of power between the states. There are many cases where the sovereignty of states have been breached through the principle of sovereign equality. It can be seen during the Cold War, where the two superpowers, the US and the Soviet, have monopolized negotiations that affected some other small states. However, these small states managed to be involved in the negotiations as well. Thus, this situation has made it possible for the parties to listen and talk to one another without any official mediation. Next is the good faith principle. So what does it mean by the good faith principle? The good faith principle in negotiation is usually to initiate the disputing parties to negotiate with strong intention and real effort to reach a fair and just solution for both parties. The negotiation aim is to be settlement and not postponement or create a false impression of cooperative attitude. Under this principle, disputing parties shall not commit any act that worsens the disputes or the international peace and security. Good faith in negotiation is also used in order to compromise and reject some claims by the disputing parties. For instance, good faith principle can be seen to be underlined throughout the legal practice of the ICJ for a few cases, such as the North Sea continental shelf. In this case, there was a disagreement between Denmark, Germany, and Netherlands concerning the delimitation of areas of the continental shelf in the North Sea. However, these states decided to negotiate with good faith to find an agreement on the boundaries of the continental shelf.
So I will continue on another two principles, i.e. the principle of cooperation. This principle is inherent in international negotiation, which are consensual activities that require the consent of all parties. Notably, some conventions mandate the use of negotiation. A party who does not engage in the negotiating process will be held responsible for not satisfying a contractual demand, and the problem will not be addressed. This notion is vital for settling conflicts over shared resources such as cross-border waterways as well as environmental preservation. When it comes to issues involving non-sovereign areas like the open sea or extra-atmospheric space, a collaboration between governments is a need. So that is why this is included in the principle of cooperation. Next, another UN resolution on principles and guidelines for international negotiation is the principle of peaceful settlement and refraining from the threat or use of force. The negotiation organization represents the assertion of two fundamental principles: the state abstention from using force in their relation with each other and the principle of peaceful settlement of international conflict. It acknowledges both the renunciation of power and acceptance of peaceful method to resolve dispute. To symbolize renouncing to force, discussion must be initiated in good faith to fix the problem. Performing negotiation can sometimes be justified by other factors, such as getting more accurate or seeming cooperative. During the US-Iran nuclear weapons dispute in 2002 until 2005, Iran started conversation on international inspection with the US European allies, giving the illusion of cooperation for a diplomatic solution. In these circumstances, the US military action would look unjustified. Iran got time to build nuclear weapons by using these approaches. Using or threatening to use force against state representative or the state itself is prohibited under these two concepts. Armed force is not permitted by international law, but political and economic pressures are. Many similar pressures are employed in international talks. During the Cold War, conversations were undertaken under the threat of using nuclear weapons. Nowadays, nations like Iran and North Korea utilize nuclear weapons to negotiate. So this principle binds governments to refrain from using force even if discussion fail and to seek a peaceful settlement.
Finally, negotiation is now the most important way to settle dispute in the most peaceful conducts. There are two main factors that must be present in order for a negotiation to take place. So firstly, a shared interest and a conflict over that interest. If these two factors is lacking, we do not have anything to negotiate with. So one of the examples of the effectiveness of negotiation can be seen in how United States and Cuba were able to work together now to stabilize their diplomatic relationship. In this case, in the end of the Cold War made it easier for these two countries to rapprochement. So the two countries could be very dependent on each other, but the actors changed over the time. So the bureaucracies on the both sides are very strong enough to make sure that the agreement made by the political leaders carry out. So that's why the dispute resolution should be conducted objectively and with complete regard for the parties' sovereignty, especially involved in this matter, so they can have a very good impact or very beneficial for both of them. Moreover, by adhering to the peaceful dispute settlement throughout negotiations, states will demonstrate their commitment to finding a long-term solution to a particular problem or conflicts. So it's also crucial to note that a conflict must be resolved as quickly as possible without the use of force and also in good faith throughout the entire process of finding a solution. This because the diplomatic negotiation can lead to a better result than what we actually planned or expected from the both parties. Thus, the importance of adhering to international law norms while resolving a conflict peacefully throughout negotiation cannot be overstated anymore. The UN General Assembly passed this principle and guidelines for international negotiation, which was approved on January 1999, is devoted to the principles and guidelines that should be followed in democratic negotiations. These principles demonstrate a clear reference for negotiation based on the list and description of international law principles which are relevant to the international negotiations. It also highlights a few perspective guidelines for how to conduct negotiation in accordance with the law. These resolutions also emphasize few main principles which are crucial to ensure that negotiation process will run smoothly and achieve their objectives. According to the preamble of these resolutions, negotiation must be guided by the principles and applicable rules of international law in order to become effective. Therefore, every disputing parties should make a negotiation in accordance with these principles in order to get the effective results. That's all from us. Thank you.